Welcome to another edition of The Productive Attorney. My name's Jim Zeta. I'll be your host. This podcast is so that you can be more productive while you're an attorney so that you can spend more time doing the things that you like to do when you're not being an attorney. Today we're going to talk about a pretty sensitive subject, and that is attorney-client sexual relationships. I handle sexual harassment law for plaintiffs. I've done some work on the defense side as well. I'm familiar with the laws on sexual harassment, and I'm familiar with some of the cases that have come out over the years on this issue. I have an attorney, Nick, who works for me. He used to be a commercial insurance adjuster, and I asked him, are there cases that you have in which you have paid a lot of money on a claim based just on a demand letter? Thinking that the answer would be no, and he said yes. And the answer is in sexually related cases where their investigation reveals some evidence of the sexual relationship or sexual issue, they will tend to pay money in those cases. As you know, we're in the middle or part of the Me Too movement, in which and the cancel culture, in which people who have had inappropriate sexual relationships are being called out. Harvey Weinstein, Jeffrey Epstein. There's many people out there who are on that list, and so that is an area in which the world right now doesn't tolerate this kind of conduct in the world. And so I thought it would be kind of interesting to talk about the attorney-client sexual relationship issue, because it is not as cut and dried as one would think. The practical advice and the takeaway from this is, if you're an attorney, do not have a sexual relationship with your client. But the answer as to whether or not that is illegal and unethical is a little more nuanced than one would think, and that's why I want to talk about in this podcast. One of the stories that I remember as a practicing attorney was this husband and wife out of here in Texas, who they decided the wife would have sex with men, and she was an attorney, and her husband was an attorney, and they hatched this scheme where the husband would act like he found out about it and would contact the guy who was supposedly cheating with his wife and say, I'm going to let everybody know about this, including your wife or your family, and they would extort money out of people. Ultimately, they were caught, and she was sentenced to 10 years probation in federal court, and he was sentenced to 5 years in jail. So that's an obvious example. They're not clients, but that's an obvious example of an attorney using sex or sexual relationships to gain an advantage. So where do we start? Where do we start when we talk about attorney-client sexual relationships? Well, before 2002, there was no model rule in the American Bar Association's Rules of Professional Conduct that banned attorney-client sexual relationships. So it was before 2002, so that's just 20 years ago, there was no model rule at all. Then the ABA passed Model Rule 1.8J, and that rule says that a lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. Now, I haven't read any cases on this, but you can't bring a potential client in, have sex with them, and then sign the contract 2 minutes later. I don't think that goes with the rules. But the question comes as the gray area as to, when it commenced, does it have an effect? And California had a rule for a long time that it's got to have a material effect on the attorney-client relationship and on the representation. And I will tell you the statistics that I've read, that out of the hundreds of complaints, only one ever stuck in California before they changed their rule in 2018. 2018, now they say you just can't do it unless there was a previous relationship there. So that's generally the rule in the model rules of ABA, but not all states have passed that rule. A majority of the states have passed that rule, but several states have not. And I want to give you an example of our great state of Texas, who they had a referendum in 2011 on this issue. about whether or not to have a disciplinary rule, a model, adopting the model rule, saying that you can't have sex with your client absent a pre-existing relationship. And our wonderful Texas bar voted it down 72% to 28%. So they just decided that we're good enough, we can handle ourselves, we can't do it. Now, there have been surveys, some are very old, that 7% of attorneys have admitted that they've had a sexual relationship with an existing client. Obviously, these are anonymous surveys, but there were surveys out there. So what's the rule? What's the rule in Texas with respect to that? And frankly, there is no rule. There is no rule in Texas. There is no rule in these other states about whether or not you can have a sexual relationship with your client while you're representing them. It's not a good idea for all the reasons you can imagine. It clouds your judgment as an attorney. It's using the power that you have as an attorney to go ahead, and it's ripe for abuse. Obviously, if there's marriages involved, it is ethically wrong and morally wrong. But imagine just two single people who decide that they want to have a sexual relationship when the client is single and the attorney is single. You've got the issues that can come up during the relationship that can impact the issue with respect to the representation. There's this case in Texas. When I was looking up the research, there's a case 2001 called Gaspard versus Beadle, Gaspard versus Beadle, Beadle. It is 36 Southwest 3rd 229. And in this case, a individual represented a husband and wife in a real estate transaction. While they were in the middle of the representation of the real estate transaction, the husband and wife go through or in the middle of a divorce. And the attorney starts dating the wife. And eventually she gets divorced and they continue dating. When they end their dating relationship, he had not sent her a bill for 2 years. And so he goes ahead and this is Mr. Gaspard, sends her a bill. Now, already we've got two mistakes in judgment, right? Number one is you don't sleep with the client. Doesn't matter if it's not related to the issue at hand. You don't sleep with your client. Don't sleep with the married client. Number two, you don't wait 2 years after representing her to send her a bill when it's just after she broke up with you or the two of them broke up. And so they break up. He's mad. He goes ahead and sends her a bill. That's mistake number two. That's error of judgment number two. Number three, when she doesn't pay the bill, he sues her. Now, even without a sexual relationship, you should not sue your client. I typically, I hate to say this publicly, but I typically don't sue my clients for bills. In fact, I don't think I ever have. If you haven't collected your money up front, if you haven't established the relationship properly, if you haven't billed them properly so that you don't get too far behind, you just go ahead and if they stop paying, you stop representing them and you write it off. And that's as simple it is, because the insurance, the malpractice insurance people will tell you that if you go ahead and sue, then there's a compulsory counterclaim and they'll sue you for malpractice, they'll sue you for everything. So the advice is never sue your client. But don't sue your client if you've had a sexual relationship with your client while you're representing him or her. That's just not right. And so she turns around and sues him, counterclaims against him, but the problem that she's got is the causes of action. What causes of action are available to her? There's no criminal statute that prohibits this. There's no disciplinary rule, so it's not legal malpractice. What causes of action does she have? So she went ahead and sued, and she sued in part. The big one was fraud, and that one was just because of material representations outside of the sexual relationship. But the other one was intentional infliction of emotional distress. And she says, look, this guy, he represents me, he breaks up with me, he goes ahead and sends me a bill, it tore me up. There was evidence in the case of friends of the lady who was talking about how she was quit her job, how she lost weight, and how she was in fact suicidal. She said she wasn't going to commit suicide, but she said that she had suicidal thoughts. The jury came back and awarded her, I think it was like $60,000 for the emotional distress. And I'm looking right here. $12,500 for intentional infliction of emotional distress, $65,000 in punitive damages, and then they assessed monetary sanctions against the attorney for an additional $20,000. The Court of Appeals overturned it. Court of Appeals said there was not enough evidence for the fraud and that there was not enough evidence for the intentional infliction of emotional distress. And so the person, in essence, got away with having sexual relationships with their client. And, you know, that goes to show that it is possible in the great state of Texas, to have a sexual relationship with a client and not have to pay for it with respect to any sort of causes of action against you. Now, there's all kinds of other issues that rise because of it, and one of them that's in a note that I've read in the Journal of the American Academy of Matrimonial Lawyers, and let me get you the name of the comment. It's in 2020, and the comment is attorney-client sexual relationships, a call for all states to adopt Model Rule 1.8J. And so this was in 2020, and they said, hey, for those of you out there, and they call it out because they have a chart here, so if you want to see if your state's in it, they have a chart of all the states who have adopted and haven't adopted it, and they said, y'all need to go ahead and adopt it. It needs to be a disciplinary rule. Lawyers need to be disciplined if they're going ahead and having sex with their clients without a pre-existing relationship, and we need to make it happen. And that's the whole part of the note. But in the note, they talk about transference. And what they mean by that is when a person will look at you as a savior. And this is not just male-female. This can be, any kind of relationship. It can be female-male. It can be any kind of homosexual, heterosexual relationship. The attorney in the relationship has the power. And the attorney in the relationship can be the savior. They can come in and they can save the day. Like Underdog when I was growing up, here I come to save the day. And when you do that, there's this concept called transference. And when there's transference, the person will transfer that hero worship to you, and you are in a position of authority. In addition, you have control because you have control of the case, you have control of the matter, you can move it as fast or as slow as you want. Plus, you have fee control. You have the ability to charge money or not charge money. In the Gaspard case, the lady had no money, and that's why the lawyer did not charge her, because he knew he didn't have any money, and so he just got mad and abused that power that he had by trying to bill her near the end of the case. And so you've got those issues, and then obviously the other issue you run into is a conflict of interest, right? You as an attorney, we talked about this in empathy last week. You have to remove yourself from the case. You have to look at the case objectively as possible. And how can you look at a case objectively if you're sleeping with your client? It's almost impossible to separate those feelings from doing your work. It can be done, but that conflict of interest is too strong, in my opinion, for you to continue to represent a client in that way. So I tend to agree with this call out that all states should adopt this rule that attorney-client sexual relationships should be banned, but for a pre-existing relationship that comes in. I don't think it'll happen. I don't think it'll happen anytime soon in the state of Texas, which brings me to my last point. I handle, like I said, sexual harassment claims. And for anybody who's been following the news, Texas is not very nice when it comes to employees. It's not very nice when it comes to any sort of expansion of the law of people's rights in Texas. It's just not. We've had tort reform kind of continuously for the last maybe 20 years. We had a major trucking bill passed in the last litigation that limits the liability on truckers. There are like all kinds of, there was 20 years ago, there was major tort reform on medical malpractice that essentially wiped it out. We've had asbestos silica that wiped that industry out. And so there's just laws that come in and wipe things out. So it is super crazy and ironic that in 2020, our Texas legislature passed laws that strengthened sexual harassment cases in the state of Texas. So it used to be that in the state of Texas, you had to have at least 15 employees in order to for an employee to bring a sexual harassment lawsuit against an employer. But now it's any employer. You can have one person. I used to tell a story because it happened in a case that I knew where you could walk around in the office in your underwear as long as you had less than 15 employees and no one really could do anything about it. I had a case in which a CEO called a staff member in on a weekend, and when she showed up, he was in his room, in his office, in his underwear. And I'll never forget asking the defense attorney, I'm like, man, what she's saying is credible, she sounds credible. And he said, well, he was in his boxers. Dude, if you're a CEO and you're in your office and you call an employee in and you're only in your boxers, I don't care if they're boxers or boxer briefs, that's sexual harassment. But if there was less than 15 employees, that guy could have been in that office and he could have had his boxers on, and that would not have been a cause of action in the state of Texas. It is now. There was another change under the Texas state labor laws. You only have 180 days to file with the EEOC or the TWC, Civil Rights Division in Texas. They changed that to 300 days, which matches the federal rule under the EEOC. Interestingly, they only changed it for sexual harassment cases. They left it alone for all the other discrimination, race, religion, national origin, that sort of thing. So now it matches and you have an additional time to go forward on the state law. Really importantly, if you're on the plaintiff side, you can sue individually now. You can sue supervisors, managers, and, quote, any others acting directly in the interests of an employer. That's important for a couple reasons. There are times that we've sued supervisors and managers, but it's never been clear whether we can or not. And one of the main reasons why we do that is to destroy diversity. If you've got an out-of-state client and you want to sue, you don't necessarily want to go in federal court. I remember a judge, a very well-respected judge, said that 75% of the employment cases that come in front of him are dismissed on summary judgment, so they never see a jury. And so that's not the same in state court. State court has looser summary judgment standards. Judges are not as inclined to go ahead and grant summary judgments for the most part. And so that's a really nice tool for us as attorneys. And also, if you have a CEO who's got a lot of money, you've got them as a deep pocket available. If they're the ones that are actually doing the sexual harassment, you have a potential claim against them and a potential claim against their assets. And frankly, if they're a CEO or a high-level guy that's doing things on the level of some of the people that we've seen now in cancel culture, we've seen now that are actually have done the sexual harassment they're talking about, yeah, they deserve to be sued and they deserve to be individually liable. Also, probably more importantly, though, was the change in the standard. Under Texas law now, an employer commits an unlawful employment practice if the sexual harassment has taken place and the employer or the employer's agents or supervisors know or should have known that the conduct constituting sexual harassment was occurring, and they failed to take immediate and appropriate corrective action. That statement, knew or should have known, sounds very familiar, and that is a standard that is used in most personal injury cases with respect to like slip and fall, a premises liability. Did they know or should have known of the unreasonably dangerous condition? And so in this particular case, you have a should have known standard, which was not there before, that can allow you to go forward more on these sexual harassment cases. And then to take immediate and appropriate corrective action. That's a little stronger than the old rule, prompt remedial action. It's prompt versus immediate and appropriate versus remedial. So it's still there. It's still prompt remedial, and remains to be seen. The cases haven't come out on it, how much that's going to be interpreted. But the know or should have known that sexual harassment was ongoing, that's huge. And so it appears that most of these cases will be in state court. And if you have substantial evidence, you have witnesses that have come forward and said, yes, sexual harassment was prevalent in the workplace, it was a toxic workplace, sex was talked about all the time, then you can go forward and bring your claim there. That also goes to lawyers, right? A lot of lawyers have small offices, have offices less than 15 lawyers. And it used to be under the old rule with sexual harassment with lawyers is, well, I have less than 15 employees, and therefore I'm not subject to those particular laws. Not anymore. You're a solo, you got a secretary or a legal assistant, and there's sexual harassment between them and you, even if there's only 2 of you or 3 of you in the office, they can turn around and sue you if you're an attorney and there's any sort of that conduct. And so it's not one of these situations where, as an attorney, we're held to a higher standard. We should be held to a higher standard. People come to us with their problems. They come to us with a problem that's so important that they're offering to pay us hundreds of dollars, and in a couple instances, thousands of dollars an hour for us to try and solve their problem, or pay large amounts, give us large percentages of their case in order to solve their problems. They put a lot of trust and faith in us. And for us to abuse that trust and that faith by leveraging that relationship into a sexual relationship is simply wrong. And most attorneys know that. And most attorneys understand that. Same thing now in the employer-employee relationship situation. You just can't do it. Especially with these changes, if you live or practice in Texas, with the changes in Texas sexual harassment laws, you just simply can't do it. So the idea is, don't do it. And that's the deal I want to give. The main thing I want to say is you don't do it. But if you live in one of the states where they say we haven't passed Professional Code of Conduct Rule 1.8J, the model rule, you may be able to do it. You may be able to get away with it and not lose your license, not get sued for it. And it's so underreported. It happens a lot. And so people get away with it probably all the time. And look, sex is a weird thing in our society right now, right? Everybody knows that obviously sex is what is used to procreate and to create more people in the world. And that is one of the main drivers of what we have. And nature has made it so that there is chemicals that are released when there are relationships between people, sexual relationships between people, that cause huge attractions. And they're a driver in everything. If you listen to music, if you watch movies, the rom-coms, all that stuff, that's all a driver in our society right now. And so when we see that and we have the biological instinct, and then you have all the social media and all the movies and everything that's out there that brings that to you, it is common to think maybe I can transfer that into a workplace situation where my instincts and urges can come over and just a little bit flow over into an attorney-client relationship, or just a little bit flow over into a employee relationship. And it's been my experience that the worst things that happened start very tiny. Happens with embezzlement, happens with everything. So maybe just one little, no one's going to know, I'm not sure it's going to happen, let's try it. And then someone does it and you get away with it a little bit. And you think, well, no one saw, no one noticed. Let's see if I can do it again. And then again and again and again. And next thing you know, it becomes a big issue. So my advice and my statement in this is simply don't do it. Just don't do it. If you are attracted to someone and they come to you and want you to represent them, and you don't have a pre-existing relationship with them, but you want to date them, you need to tell them, I can't represent you as an attorney, but would you like to get a cup of coffee? Now, I think 9 times out of 10, they're going to tell you, no, the relationship I wanted was transactional. I wanted you to be my lawyer. I don't want to go out with you. But that's the ethical and right thing to do, is just don't do it. So I guess that's the motto of it. Attorney-client sexual relationships. Who would have thought that in this day and the age we would have such a nuanced answer? But that's the answer. Hope you enjoyed this week's talk, and have a great week. Thanks.